Good morning. This is the House Government Operations and Military Affairs Committee, and it is Thursday, February 9th. We're here this morning to talk about a miscellaneous bill with a number of topics in regard to the Office of Professional Regulation, the OPR bill. And so welcoming Tim from Ledge Council. And Tim, please walk us through the bill. Thanks for being here.
Thank you very much. And thank you for having me today. For the record, my name is Tim Devlin, Legislative Counsel. This is a committee bill relating to professions and occupations regulated by the Office of Professional Regulation. In essence, there are 5 parts, 9 sections, and 10 pages. Amendments range from modifying disciplinary processes to codifying remote continuing education course options for all regulated occupations, to the occupation-specific items regarding cosmetology, osteopathy, and pharmacies. It also recognizes recent federal preemption, necessitating exempting dispensing over-the-counter hearing aids from requirements of state law. I will start at the bottom of page 1, or again to the substance of the bill. Section 1, and sorry, this is the reader assistance heading, starts with Office of Professional Regulation. Section 1 contains 2 modifications to Title 3, Section 129, subparts E and N. E reduces the number of appeals when an appellant is pre-denied in a license on the basis of insufficient qualifications, and N enables a board to designate a 3-person panel in disciplinary hearings rather than a full board or fully delegate the matter to administrative law officer for decision. I will now go through the exact language. So we have, and I'll skip to the top of page 2, subsection E1. When a board or the director, in the case of professions that have advisor appointees, intends to deny an application for a license based on the applicant's past or current unprofessional conduct, or based on ongoing investigation of the applicant in Vermont or elsewhere for unprofessional conduct, the board or director shall send the applicant written notice of the decision by certified mail. The notice shall include a statement of the reasons for the action and shall advise the applicant that the applicant may file a petition within 30 days after the date on which the notice is mailed with the board, mailed with the board or the director for review of the board or director's preliminary decision. We then insert 2 subdivisions, A and B here, above subdivision 2. Reads beginning line 11. At the review hearing, the appellant shall bear the burden of proving that the preliminary denial should be reversed and that the license should be granted. Subdivision B. After the hearing, the board or the director shall affirm or reverse the preliminary denial, explaining the reasons therefore in writing. New language in subdivision 2 in the subsection. The decision of the board or director in the case of professions that have advisory appointees to deny an application for a license based on the finding by the board or the director that the applicant has not fulfilled the qualifications or met the standards required for licensure shall be a final decision of the board or director. There are some policy implications to this, and I will defer to the Deputy Secretary of State as well as the General Counsel of OPR, who will be following up next. Moving on to the top of page 3, new subdivision A. Upon such a final decision by the board or the board or director shall send the applicant written notice of the decision by certified mail. The notice shall include a statement of the reasons for the action and shall advise the applicant that the applicant may appeal the decision of the board or director to deny the application by filing a notice of appeal with the director, who shall assign the case to an appellate officer.
Tim, real quickly, just for clarity, I know that we're moving sometimes with language like this from upon such to a final decision under the subsection in order so that the such I think tends to be tough for plain reading. I know that a number of times in with drafting, we've kind of gotten rid of the suches and gone to a more specific language. I don't know if that's just a style carryover from the old days, because I know a lot of this language came directly from OPR and wasn't Smith in-house, but I was just wondering if that was maybe a little cleanup that we could do when we see another draft. I just wanted to flag while we're going through.
Flagging the of suches?
Yeah, just that style piece, just
Yes.
to make sure it's a little
I can.
bit easy to read.
Okay.
Real old school lawyer language, all those suches. And you're like, what are you talking about?
Understandable.
Your mental stride, yeah.
Let's see. I believe I was on page 3, line 7, subsection, subdivision B. Appeals of decision by the board of directors to deny an application for licensure based on the qualifications of an applicant shall be conducted in accordance with Title 3, Section 130A. The record in the appeal shall include the applicant's application for the professional license, a written notification of the decision to deny the application, and any other materials established in rules adopted in accordance with Title 3, Chapter 25. Now, moving on to subsection N of this, and again, this enables a board to designate a 3-person panel in disciplinary hearings rather than necessarily going with a full board or fully delegated outside. N1, starting on line 14, reads, a board may designate a hearing panel consisting of less than a quorum of the board to conduct hearings that would otherwise be heard by the full board. A hearing panel shall consist of at least 3 members, including at least 1 professional member of the board and at least 1 public member of the board. No member of the hearing panel shall have been a board member who was assigned in accordance with subdivision C3 of this section to assist the office investigators and prosecutor in relation to the investigation and prosecution of the matter being heard. The director shall establish by rule the process for designating a hearing panel. I'm now at the top of page 3, going into line 3, which is subdivision 2 here. If there is an insufficient number of board members to serve on a hearing panel by reason of disqualification, resignation, vacancy, or necessary absence, the director may appoint ad hoc members to serve on the hearing panel for that matter only. Next, subdivision 3 in line 7. If a board is unable to convene in a timely manner to hear a disciplinary matter or to appoint a hearing panel, the director may designate a hearing panel to hear a matter that would otherwise be heard by the full board. If the director appoints a hearing panel, the director shall follow the requirements of subdivisions 1 and 2 of this subsection. Moving on to subdivision 4 in line 12. The hearing panel shall be designated solely upon request and decision of the board or the director in accordance with the subsection and rules adopted by the director in accordance with Title 3, Chapter 25. That concludes section 1.
So we're going to hear from the deputy secretary, who is currently still, I believe, acting as the director of the Office of Professional Regulation, about the context for all of this and why they are recommending these changes after. But just in terms of the words on the page, Tim, I want to just ask a couple clarifying things. So director in this section always refers to the director of the Office of Professional Regulation.
It does.
And the boards that we're talking about are boards of professionals who advise and approve licenses on those professions that have boards that advise the director in that way.
Yes, I'd agree with that. And for drilling down into that, I would defer to the folks coming from OPR.
All right, great. So new processes, we'll hear the context, but any questions about section 1 words on the page as opposed to the why, which we'll get into with Director Hibbert.
Thank you, Chair. Chair said boards of professionals, and you agreed, but there are public members of the board also who are not necessarily.
Yes, that is correct, actually, yes. Okay, moving on to section 2, and this is at the bottom of page 4. And this pertains to Title 3, Section 136. The This proposes modifications to permit the continued use of synchronous virtual continuing education courses when a licensee needs continuing education credits to renew their license. By virtue of putting this into Title III versus Title 26, where we find the statutes addressing each occupation and profession in particular, this broadly applies to all regulated professions and occupations under the purview of the Office of Professional Regulation.
Tim, what do we mean by synchronous virtual continuing education? When we use synchronous virtual, what are we talking about?
I can't speak too much to the technical meaning of that. As I understand it, it's remote learning, but I will defer to OPR coming up next for that. Starting on line 16, section 136, uniform continuing education evaluation and form. Subsection A, subdivision 1. And this is not modified in the language. It's actually reconfiguring the ordinal pattern of subdivisions versus subsections. I can skip down to the pertinent language, or I can read through that depending on what the chair prefers.
No, that's fine. Just the reorganization of the numbers. I'm not. We're just doing that because we're adding.
Yes.
A section 2.
So I'll skip down to the bottom of 5 then. Subsection B presents new modified language. When completion of continuing education is required for renewal of a license regulated under this title, synchronous virtual continuing education courses shall qualify as live in-person training and be accepted for renewal of the professional license. It's a brief and sweet section, so unless there's any questions, I'm happy to move on. Okay. The next part of this bill pertains to barbers and cosmetologists, particularly cosmetology. And this is just one section, section 3, and that involves Title 26, section 281, Post-Secondary School of Barbering and Cosmetology Certificate of Approval. And before jumping into the actual language, this permits state correctional facilities to offer courses in cosmetology in addition to barbering without a certificate of approval from the director of OPR. Don't believe there's any scope change here.
And just since we do have some new folks in any of these sections, when we're doing a housekeeping bill, any bill, you'll get used to this, but we're reading all of the words that are on the page that don't have a strike or an underline. Those are existing statutes. So Tim, barbering is already covered under this, and all we're adding is and cosmetology.
Correct.
Representative Morgan, did you have a clarifying question?
No, I would just.
Yeah. We have. I know we have 3 new members to the legislature, and be like, wow, this is a whole lot of new stuff. But the new thing is just the underlying piece or the pieces that are struck.
I'm happy to read through that language or pass it.
I think we got it on that section. Thank you.
The next part involves osteopathy. And this is, again, one section, section 4, pertaining to Title 26, section 1836, biennial renewal of license continuing education. In essence, these modifications sync the requirements for osteopathic physicians or DOs to allopathic MDs, and provides the director of OPR rulemaking authority for the renewal of lapsed licenses and the board rulemaking authority to establish requirements for continuing medical education beyond the hour requirement, or further specifying, I should something say. Since this is a lot of new, as indicated by the underlines language, I'm happy to go through this. The bottom of page 6, line 20, I'll start with the new subdivision A1. A license issued under this chapter shall be renewed every 2 years upon application, payment of the required fee, and proof of completion of required continuing education. Failure to comply with the provisions of this section shall result in suspension of all privileges granted to the licensee beginning on the expiration date of the license. Subdivision 2, line 5 reads, a license that has lapsed shall be renewed upon payment of the biennial renewal fee and late renewal penalty. Moving on to subsection B.
Representative Morgan.
Just a quick one on that, unless I missed it, Tim, would that then, they would still stick with the current dates? It wouldn't fast forward and say they were 2 months late? They would continue with the old dates, I assume, not, do you see what I'm saying? Not, so if I was 2 months late, I wouldn't fast forward and get, say it was due January 1st, I wouldn't, and I did it March 1st.
So what you're asking, does it start the cycle when you pay late?
Correct.
Like on a 2-year?
Yeah, I think it would keep the same cycle, right?
And I'm not too sure about that aspect. I would defer to
OPR,
your
okay.
OPR staff coming up.
Just curious. I assume probably so, but okay, thanks.
I think Deputy Secretary Hibbert will definitely be able to cover that easily. I think this housekeeping bill allows us an opportunity to really dig in and learn a little bit more about some of the processes and the way that the Secretary of State's Office of Professional Regulation covers many of these things, license renewals, boards that oversee the various professions. So Tim's given us the words on the page, but we'll dig into the policy pieces with Deputy Secretary Hibbert. Please continue.
Thank you. Picking up on subsection B, the new text beginning on line 10 of page 7, or midway through page 7, sorry. The director may adopt rules necessary for the protection of the public to assure that an applicant whose license has lapsed or has not worked for more than 3 years as an osteopathic physician is professionally qualified for license renewal. Conditions imposed under this subsection shall be in addition to the requirements of subsection A of this section. Subsection C reads, as a condition of renewal, a licensee shall complete a minimum of 30 hours of continuing medical education during the preceding 2-year period. The 30 hours of continuing medical education shall meet the requirements established by the board by rule. And that concludes that section.
Please continue.
Okay. The next part regards pharmacies. Across the next 3 sections, that is 5, 6, and 7, there are the following modifications being proposed. 1, to permit subcutaneous self-administered hormonal contraceptive, or depot shots, as I believe they're more casually called, permitting pharmacists to continue to administer all vaccines, and permitting pharmacy managers to no longer wait a year after obtaining a license to operate a pharmacy in Vermont. The particular language, let's see, starting with section 5, Title 26 VSA section 2022 in definitions adds 1 word into the definition under subsection 21. Under the definition of self-administered hormonal contraceptive, adds subcutaneous there. Line 9, I have to read through that, just kind of skip down.
Yeah, so what is that subsection covering? I think it's
Sure. This section is definitions which play into the, as they're used throughout the remaining, associated sections within the chapter. This, as far as how this definition is kind of occurs in practice, or how subcutaneous plays into the use of these contraceptives, that's more of, I would say, a policy question. I would defer to OPR coming up next, but I may not be understanding your question. I apologize.
Yeah, I guess just, so this chapter, we're just seeing the one paragraph 21 here.
Yes.
I was just wondering if these definitions all pertain to pharmacy scope of practice, right?
Yes, as an understanding, yes. Section 6, or sorry, would you like me to read through that definition whole?
No, that's fine. Thank you.
Section 6 regards Title 26, Section 2023, clinical pharmacy prescribing. And this has some new language, so I'll just kind of read it through as it kind of logically occurs, skipping some in between parts which are not as material to the business today. State protocol A pharmacist may prescribe, order, or administer in a manner consistent with valid state protocols that are approved by the Commissioner of Health after consultation with the Director of Professional Regulation and the board, and the ability for public comment. Self-administered hormonal contraceptives, including subcutaneous depot, medroxyprogesterone, acetate. Then also,
I'll remind the committee that Tim graduated from law school. He does not
Yeah,
have a
I'm
degree in
like,
biochemistry.
I'm like, can we get some explanation? Give me like brief Google pause. Because I've been doing a lot of Googling.
apologies for stumbling over that one.
I think you did fine, Tim.
No, you did great getting, like orating it. I'm just trying to unpack what it actually means.
And then I'd like to just kind of break from that first concept, moving on to the next section or subdivision here at the top of page 9, starting on 4. This gets to permitting pharmacists to provide all vaccines. And again, policy reasons underpinning this, defer to OPR on this, but the language reads, for patients 18 years or older, vaccinations recommended by the Centers for Disease Control and Prevention Advisory Committee on Immunization Practices, ACIP, and administered consistently with ACIP-approved immunization schedules as may be amended from time to time.
Representative Hango has a question.
Thank you. What does this mean as may be amended from time to time? Amended by whom?
It's the Food and Drug Administration.
We can't dictate what the Food and Drug Administration does.
So I think we're going to get into this with Deputy Secretary Hibbert's testimony, but if I'm understanding it right, what we're doing is aligning Vermont's scope of practice laws with the FDA allows, and we're saying pharmacies can do these things and administer these particular vaccines that are authorized by the federal government. So we're aligning Vermont with that, but Deputy Secretary Hibbert, I think, is going to do a better job.
Is that your understanding?
Yes,
Tim?
I would also add to that, I think what is being amended from time to time is the immunization schedules, which are set by.
Okay, thank you.
Representative Chase.
Just double check on line 1, including, but not limited to, right? That's the use of that.
I'll have to think about that. So section 5, this is the previous.
Page 9, line 1, yeah.
Okay. Self-administering hormonal contraceptives, including, but not limited to subcutaneous. Okay.
Is that an accurate interpretation?
As far as statutory construction, including something would, it wouldn't be a definitive enumeration to the preclusion of any other things. That wouldn't necessarily be limited to just that.
Thank you.
Section 7. And this is jumping back into pharmacies. This pertains to pharmacy managers, bringing in line with national rules, I believe. Let's see. There is, this is Title 26, Section 2061, registration and licensure. This removes the 1-year requirement for pharmacy managers before they may manage a pharmacy in essence. Read that through if you'd like, or
Representative Hango has a clarifying question, and I'll try to.
Thank you. So by removing that language, if a pharmacist has had a restricted license and now has an unrestricted license, the next day they could be made the manager of the pharmacy.
I'm not too sure about the
Okay.
implications of this. I think OPR can speak to that
Okay.
and probably provide a lot more detail as to what that looks like in practice.
Thank you.
The next part of the bill pertains to audiologists and hearing aid dispensers, in particular, hearing aid dispensers. This is the last part. This modifies existing law to recognize recent federal preemption. This exempts persons dispensing over-the-counter hearing aids from the requirements of state law. And this adds a new subsection B on, let's see, this is line 11 of page 10. The text existing above this or before this is not slated to be modified, so I'll just kind of skip down to subsection B. In accordance with 21 CFR, Code of Federal Regulations, as section 800.30, persons dispensing over-the-counter hearing aids as defined by 21 CFR, section 800.30B, and meeting the standards established in 21 CFR, section 800.30 C through F, including self-fitting air conduction hearing aids as defined in 21 CFR, section 874.3325, shall be exempt from this chapter.
Representative Hank.
Thank you. I'm sorry, but when the bills are condensed like this, I need a lot of clarification. What are we exempting them from?
Is exempt, I believe there are various requirements for those persons or establishments selling hearing aid dispensers, that are hearing aid dispensers selling hearing aids. The OPR can kind of maybe is certainly more informed than I am and can give you an overview of what the regulations for those folks actually typically entail. This puts them in the category of exempting them from all the state regulations. I know that's basically me just rephrasing what I said before, but.
Yeah, I think that this chapter covers the scope of practice for audiologists, and we're going to hear from Deputy Secretary Hibbert about new federal laws that make it easier to sell over-the-counter hearing aids of types that previously had to be prescribed. So that's what we're getting at here. But we'll defer to Deputy Secretary Hibbert, and she'll be able to put this into some context for us, I think.
I think I just want to comment, and this is a general comment, when we're presented bills like this, it's really helpful to have the other statutes like side by side, the ones we're amending, because we don't know what we're.
Representative Pango, I'm going to ask for your patience and say, welcome to Gov.Ops.
It's not just your committee.
Yeah, I will do that as much as possible. I would also say that we're pretty reliant here, without delving too far, on Legislative Council and the Secretary of State's office around the specific applicability of those, federal codes. We're definitely not going to dig into the CFR 800.3 and trust that Legislative Council and our folks who are presenting the language from the agencies and administrations have got the right cross-references, but those are the kinds of things that make it a little bit tough for us to completely understand how all of the things connect. But
Understood, but I was referring to actually our statute, 26 VSA 2061. I was not referring to the federal code. It says 26 VSA 2061 is amended to read. So I was wondering what we were amending of our statutes, but I can always try to look that up if Leg Council can't tell me.
Regarding pharmacy managers.
so this is back on section 7.
Yeah,
pharmacy managers.
Sorry, yeah. Well, that pertains to, 3286, sorry, not 2061, 3286.
The exemptions
Yes.
under the chapter for audiologists and hearing dispensers.
Yeah,
Can give you some more context as to where that resides in Title 26.
just what it is. I mean, we're being asked to amend it, but we don't have any reference point unless we try to look it up, what we're actually being asked to amend.
So what I would say is a couple of things. We have access on the legislative website to the entire Vermont statutes annotated online. So if you want to pop in section 8, VSA 3286, We will take more testimony on this. All we're seeing right now is the language that's being presented as a prelude to hearing testimony on it. So we'll be going back through this with more context. So I appreciate everybody being able to sort of suspend disbelief while we just get a lot laid on the table, and then we'll go back and start putting some context.
Great, thanks.
Representative Chase, are you good?
Yep.
Tim, I think we're on effective dates now, and then I can get you out of the hot seat. We can start getting some of the questions answered.
And so section 9, effective day, this act shall take effect upon passage. And that concludes the spell.
Representative Boyden.
I have a question that jumps back to section 2, effective day.
Sure.
Line 20 at the bottom of page 5. So with remote learning, there's synchronous learning where the instructor is in one place, learners are in another, and we're teaching and learning same time. But then there's also asynchronous where the instructor, say, uploads the materials and you can complete the course on your own time. So I'm wondering, with just using the word synchronous, are we not allowing asynchronous learning for renewal of licenses?
To OPR committee. They can certainly delve into that.
Thank you.
All right.
Okay.
Thank you very, very much for walking us through the words on the page. And now, our much anticipated, we have not one, but 2 Laurens joining us.
Sounds like a lot of lived experience.
Good morning.
Good morning.
Hello.
You guys feel very far away in your new configuration.
Yeah, it's a big committee, so we've needed to have some room for everybody. But it does make things, we're really using the room here. So would you record and please help us, you heard many of our questions about the language on the table for this OPR bill. And also I wanted to ask, we skipped a year and had no OPR bill last year, right?
That is correct. And for the record, my name is Lauren Hibbert, Deputy Secretary of State, and I have with me
Lauren Lehman. I'm the General Counsel for the Office of Professional Regulation.
And we did not have an OPR bill last year, and we typically do, and we typically begin it in House Gov.Ops, but we chose not to have an OPR bill last year out of respect for House Gov.Ops committee last year. That does not signify that we don't have respect for this year's House Gov.Ops committee. It just was the scope of work that was on the plate for House Gov.Ops last year. And we didn't have anything emergent. So we chose to hold our issues until this year, and here we are. I did file testimony this morning. I apologize that it was, an early morning submission. But I wanted to give you all a little bit of a deeper background on the Office of Professional Regulation before we jump into the bill. I know that I came and did an overview with the Secretary of State now 3 weeks ago, I think. But there are some new members to this committee and some new legislative members altogether. So I think it's just a good refresher for all and new information for some. We oversee 51 professions, everything from tattooists to veterinarians, nurses to dentists, cosmetologists to accountants, well drillers, home contractors. It's a really expansive and diverse list. We have just over 85,000 licensees. That can be businesses. We regulate businesses and professionals, so obviously people. We have 2 different models of regulation. One is the board model, which Tim, Legislative Counsel, I apologize, spoke to, where we have a board of professionals and public members who help with the way we regulate a profession, help with the administrative rules, hear the administrative hearings. And then we have the advisor model where we have professionals and sometimes a public member or 2 that advise our office on how the office should administer the licensing program. Our statutes can be found in two different places. They can be found in Title III, which is represented in this bill, and the majority of the profession-specific statutes are in Title 26, although some are in 18. I believe there's some stragglers out there, but the majority are in 26. Our team consists of 40 employees. When we're fully staffed, we have some vacancies, including the director position right now, which I have 1 foot in at all times until that's filled. We have 9 licensing administrators. These are the people on our front line. They are helping applicants obtain a license, and they are also helping our professionals get renewed. We renew every 2 years, and to your question, if somebody renews late, the renewal cycle is at the standard date. It doesn't begin when you restart.
You don't restart your cycle.
That is correct. And we really love that rigid start for us because we are cycling through so many licensees over a 2-year period. It's quite a burden. So we need to keep people in their slot. And we are very careful about when we adjust renewal periods or when those things shift in any way because of the staff implications. If you average out our licensing team, we have a supervisor. So approximately every licensing administrator is responsible for about 10,000 individuals, which is a huge amount of responsibility. And a lot of our licensing applications are very complicated. Some are simple, but some are very complicated. And those relationships that those licensing administrators establish with our applicants can be multi-month long conversations about how to get somebody to meet the qualifications or to get all of the documents, which is relevant to part of this bill. We also have an enforcement unit. That is when a professional commits unprofessional conduct, we receive a complaint. We have an online complaint reporting tool. We receive anonymous complaints, complaints from employers, complaints from patients, complaints from consumers. We screen all of our complaints. We receive approximately 700 to 800 complaints a year. We screen them. If they're screened in, they're investigated. We have 9 investigators, 5 of which are certified law enforcement. So they look at our complaints from a criminal perspective and a civil administrative perspective. We have 4 prosecutors who represent the state of Vermont. We have 2 case managers and a paralegal. We bring about 120 to 150 unprofessional conduct cases a year. Some of them are summary suspensions because we have drug diversions in facilities, and so we need to immediately suspend somebody's license. We have instances where professionals are violating professional boundaries and having, a very classic example of this is a therapist who's having a sexual relationship with one of their clients. So we have a pretty wide scope of cases, and we need to be able to take quick and immediate action when necessary. We hold our administrative hearings, our disciplinary hearings, and our pre-denial hearings in front of administrative law officers. Our disciplinary cases are held in front of our boards. If it's an advisor profession, it's always held in front of an administrative law officer. And if it's a board profession, then it's almost typically held in front of the board. We also have 2 inspectors. We inspect all of our businesses. So that is barber and cosmetology shops, tattoo shops, electrology shops, pharmacies, funeral homes and crematoriums, did I say pharmacies already? Pharmacies, real estate, body piercers. There may be some others, but that's the gamut. And they're out in the field every day inspecting. And then we have a general counsel unit, which has 3 lawyers in it who help the office on all legal questions, and then also help the boards and the advisors do their work. So as I stated in the beginning, with our 51 professions, they're constantly changing, and you'll see that theme throughout this bill. We need to respond to federal law changes, to consumer demands and marketplace conditions. And that's why we bring an OPR bill, is because we're trying to respond to that. If it's okay with you, maybe I'll pause there just for if there's any questions about OPR before I get into any details of the bill.
Go ahead. Good morning.
Could you say one more time, Lauren, those three factors you just said?
Yes.
Please.
Federal law changes, consumer demands, and marketplace conditions.
Thank you.
There's probably, I wrote that this morning, so I could have probably put some more thought, but I would say the biggest thing that we've responded to in the last several years has been COVID.
Right.
Which I guess is consumer demands and marketplace conditions in a way. But we have been on the forefront of and trying to be good partners with our institutions in responding to COVID. Last year, one of the reasons it was with respect for the House Gov.Ops committee, but last year we also did a large bill on telehealth that affected every single one of our healthcare professions. That was our biggest legislative priority last year. And what that did was create a telehealth registration and license for every healthcare profession so that an out-of-state professional could provide telehealth services to someone who's located in Vermont. And that was a significant lift before the session, and it was our big legislative action last year. So while it was not an OPR bill, it was the work that we did last session.
And you would call those drivers, I guess, of your decisional tree, or how do you?
Yeah, I think those are drivers of what we're always looking for. We have a very wonderful philosophy at the Office of Professional Regulation, and it's built right into the statute. It was a mandate from the legislature. You can look at it. It's in Title 26, Chapter 57. That is our sunrise and sunset and scope revision bill section of the law. It really demands that our office regulate a profession to the minimum necessary to protect the public. So first we have to ask, does the public need to be protected? And second, and if we say yes, then second, we need to ask, what is the minimum necessary to protect the public? It's a very libertarian way to look at occupational licensure. And it's really become a model across the nation because occupational licensure is a barrier. All of it is a barrier to being able to do the work that somebody wants to do. And, when I, as director of OPR, when I was interviewing people, in the final stages of the interview process, I would always say, I just need you to remember that you are the person that will unlock the second question at a cocktail party, which is, what do you do? What do you do is so foundational to who people are and how they make money, how they support their families, that we need to be careful about making sure that we're not setting the barrier too high, that we're providing excellence in making sure that we get people into the marketplace as quickly as possible so that they can start working, that we are constantly reviewing our processes to make sure that we are not a barrier to people. And then with that is, if somebody steps outside of the lines or commits unprofessional conduct, that we're efficient, that we are making sure that we're removing them from the practice of the profession so that we can protect the public. So I would say that those three factors plus Chapter 57 are our marching orders and something that we talk about every day, and we try and really ground ourselves in those principles.
All right, thank you.
Representative Morwicki.
Good morning. Thank you for coming.
Good morning.
I know you're here to talk about this bill, but I have a question that I could get an answer to later because you didn't come prepared to do that. But in the past, I think even before COVID, we were having the experience of new Americans coming to Vermont, to this country, with credentials from their country of origin, but not necessarily translating easily. At some future date, could you update us on that situation?
I can update you on it now.
To take the time, I'd like to hear.
Yeah, if you want to try to,
Okay.
we've got a lot to do with the bill, so yes, if you.
So what Representative Murwicki is talking about is several years ago, we had a bill that encouraged us, required us to, and with our full support, to draft rules on how we could assess credentials from for someone who was trained in a foreign country. I'm very fortunate. I have the author of those rules sitting right next to me, and they have been adopted through LCAR. And what those rules outline is that somebody can use a third-party credentialing service, which exists in the marketplace, to have their credentials from another country assessed. There is a process by which if they can't provide the documents to that third-party country because they fled in an emergency fashion, or the institution where they went to school, was bombed or something like that, that the director could take that into account and use his or her discretion to overcome that barrier. But we have, I think, done this maybe 5 times now, and we have a couple more in the pipeline. So we worked really diligently with New Americans groups to get their feedback on the rules, and we also have been trying to expand the knowledge base that's even available. There's more to be done.
Thank you.
Do you have a question?
I did, but I think Shay had her hand up before me.
I'm good. I can wait.
Okay. And I was just this is actually just more like clarification for license and function, right? Like, so you have all the licenses that fall under your purview with inspections, but then there's also like hospitality and lodging. That's like a totally different bucket. And I just actually wanted to point that out for like new members who are foreign to this, that there's even like a broader bucket of licensure and inspection that goes on with a bigger pool of inspectors and whatnot. So just throwing that out there.
Would it be fair to say that OPR licenses individual professionals, and that occupancy, safety, the spaces are under the public safety, which is also in our purview, but.
In Department of Health.
Not where we are
like,
today.
yeah, totally.
Yeah.
Like, yeah,
Yes.
Food and Lodging is Department of Health, and that's just yeah.
Yes, and if I could just expand a little bit. The other professionals are licensed by other state agencies, and before COVID, we did file a report with the legislature that didn't get a lot of movement or traction. We were asked by this committee to write the report with the governor's team, looking at regulatory structures around occupational licensure across all of the state agencies. So for instance, the Agency of Education licenses teachers and the related professionals that go into schools. The Board of Medical Practice is located in the Department of Health. They regulate half of the physicians, well, half of the type of the physicians, but the majority of physicians in the state. They also license podiatrists and anesthesiologist assistants and physician's assistants. And then, as you probably know, electricians and plumbers are regulated by the Department of Public Safety. So there's lots of pockets of occupational licensure across the state, but OPR is the biggest, and we regulate the most professions.
Representative Hooper.
Thank you, Mr. Chair. In reference to Representative Murwicki's question, I might have missed, but when we get a foreign national who comes in and it looks good on paper, is there an actual practicum supervised period test under a professional that's already licensed to make sure that their competence is?
So the examination, Lauren Lehman, for the record, I think I already did that, but there is an examination that can be required. So the process is the individual would reach out to the Credential Evaluation Service. Many of them have documents and records with schools in these countries already, and they're able to verify somebody's credentials, attendance, course of study. They provide a report back And that report is then submitted to OPR in lieu of the full application. But the examination or supervisory period would still need to be completed. We have had instances where people are able to supply a work documentation of 20 years of work. And in those situations, we would not make them repeat their supervised practice, but the competency examination is always required.
Representative Hanko.
Thank you. That brings up another question. Do you do the same thing for other professions that your office regulates in terms of foreign nationals coming in and wanting to practice here?
That covers all of our professions, those foreign credentialing rules.
How often has that been used now are there a lot of applications to go through the new process, or is it something that's so new that it hasn't really had time to?
I don't know that we have specific numbers. We could look into that. We have recently had a cosmetologist and a nurse that have come through that process. We hear about it. I think staff just uses it as part of their process. So we only hear about it if there's an issue. So we'll have to reach out to them. Yes.
Representative Higley.
Yes, thank you. I'm sorry for being late, but as long as I've got you here, Deputy Secretary, I'd be interested to know, I believe it was December 1st was the startup period for contractors to sign up. And I'm just wondering what that number looks like at this point.
I think that we just sent out another communication to the home contracting field. We're trying to cast a wide net, and there's obviously a lot more that we need to do to get the word out. I believe that we're at just 200, which we know is not the amount. So we've got our work cut out for us on making sure that we are, talking to the lumber yards and hardware stores to get flyers up. Have a little speaking tour, hoping to get on a speaking tour with some local radio stations. So yes, and if you have any ideas, I'd love to hear them.
Okay, thank you. No, I think that sounds good. Reaching out to the lumberyards would be a good start, I think.
Can I add to that one?
Yeah, of course.
So last week and the week before, we did 2 presentations. Me and one of our staff members, our administrative director, and with a Southern Vermont building organization that has statewide representation. About 50 people joined there. And with Efficiency Vermont, we had about 200 people in that. And we reached out in our initial email to about 25,000 people after combing through corporate records and seeing our corporate names to see who's in that. So that's one avenue, but we've also developed posters through those meetings last week. We offered the poster for them to post. So we're really on the beginning process of it, but we have that resource available. If you know of any organizations that want that presentation, we're really happy to do that. We'll also have a webinar posted on our website if folks just want to do that. So.
Again, especially up my way, I think there's not a lot of folks that are in the industry that are a member of, say, the Home Builders and Remodelers Associations or any industry whatsoever. So I think those are the ones that are going to be hard to connect with unless it's through like the lumber yards and that sort of thing. So I think that's a good avenue for those folks. So thank you.
Thank you for that feedback.
We're pretty much done.
Well,
I'm going to go off topic.
So just for table setting, right now we're at I hope we're reaching the end of kind of introductory comments, but I want to hear our guests talk about the bill itself. So we're going to walk through the bill and start to understand the context of the entire bill.
You and I talked before the meeting about the proliferation of compacts that are coming to the table. And we did nurses last year. And I've heard people from other states say that has taken away some of their ability to regulate, and it hasn't been as beneficial. I've heard other people say they love it. Can you just give the committee an idea of what you do to evaluate compacts and their impact on?
Yeah. So I'll do a very brief response now because I'm coming back here at 2:15 to talk specifically about compacts.
Then forget.
So if that's okay, I could wait entirely until 2:15.
I actually think we have more time this morning than we may have this afternoon. So if
Okay.
you wanted to spend a few minutes just talking generally for some table setting about compacts and how there is a proliferation of them across
Sure.
multiple professions, that might be useful as just kind of teeing up the thinking about that for this afternoon. So the committee knows you've probably seen on our agenda that Representative Houghton has been scheduled to come in and do a drive-by of 3 healthcare profession-related compacts that have come before their committee. And so Deputy Secretary Hoover, if you want to kind of give a little frame up of what's been going on, the sort of context setting, I think would be helpful this morning, and then we'll get into it this afternoon.
Absolutely. So compacts are a really growing tool in occupational licensure. Compacts are an agreement between 2 states, and we actually have lots of compacts in our lives. So a very common example of a compact is the driver license compact. That compact allows, if you're a driver in one state, you can drive in all states. The occupational licensure compacts have a very similar model. If you are a licensee in one state, you can practice in another state. There are some logistics and variations between the compacts of how that actually happens, but that's the basic high-level model. There's almost always the concept of the home state. That's the state where you live. It's the state where you drive, where you vote, where you have a house, where where your kids go to school. And then there could be the state where you practice. And that's the authority to practice in the other state. And sometimes that authority to practice just happens because you're in the state. Sometimes it happens because you ask for the authority and you have to pay an additional fee. And then the entire underpinning of all the compacts is if you move to a new state, you have to get a new home state license in the new state, a new compact license in the new state. Very much like the driver's license, right? If you live in Connecticut, if you come to Vermont and you decide to live in Vermont, you have to get a Vermont driver's license. You can't just continue with your Connecticut driver's license. Compacts are really effective tools. They are really effective at helping with mobility, helping the workforce as it goes across state lines. If you think about something like the healthcare workforce, it is not contained within Vermont. One of the big things that happened during COVID with the COVID flexibilities, I was testifying about this yesterday in House Health. We had, I don't remember all of the ACT numbers. There's now been, I think, 4 of them that relaxed licensure during COVID because of the fact that healthcare goes across state lines. So when COVID happened, there was an immediate recognition that if we were going to be constrained to our state, I mean, it's amazing to think about all of the things that we went through so quickly as a state in the spring of 2020, as a nation, as a world. But one of the things is we were told to not travel and to not go across state boundaries. And many of us abided by that. And that had an impact on people's healthcare, particularly if you live in, the upper valley of the Connecticut River. Your healthcare almost entirely is across the river at Dartmouth Hitchcock. And those folks do not have a Vermont license. They didn't need a Vermont license before because the Vermonter would come across the river and receive the care, and the care was happening in New Hampshire. But all of a sudden, the care was happening in Vermont because we were using telehealth. And those providers on the other side of the river needed to have authorization to work in Vermont because a general principle in healthcare is that you need to be licensed where the patient is, not where you are, but where the patient is. And all of a sudden, all of those New Hampshire providers, their patient was in Vermont. So we allowed them to practice. With compacts, a lot of that is simplified because someone who's part of a compact can provide care to a Vermonter. So for instance, the nurse licensure compact. A nurse can provide care to a Vermonter and be in Virginia, doing telehealth in Virginia. And there's not a problem. So compacts really solve a variety of problems, mainly mobility and telehealth. They can also, and this was a consideration and implementation of the nurse licensure compact, they can start to be considered as a recruitment tool for people to stay in Vermont because they want the compact license, or for people to move to Vermont because they want the compact license. And I do think that was a factor in the nurse licensure compact. Compacts almost always have a revenue impact on the state. I haven't talked about money, I don't think, in this committee yet. But the Office of Professional Regulation is a siloed special fund, meaning we only subsist on our licensing fees and revenue. And if with compacts, we lose licensees, which means that we lose revenue. So this is a really relevant problem for OPR this year, but it also is a very relevant factor when you think about the fact that we're a small state. And so it used to be that if somebody lived in New Hampshire and worked at Northern Vermont Regional Hospital in St. Johnsbury, they had a Vermont license. Now that nurse does not need to have a Vermont license. He or she can just come across the border and work with their compact license. So we lost the revenue from that New Hampshire nurse who works at NVRH. And that's had a fiscal impact for us. So we're in the beginning stages of really we're in the middle stages, I would say, of really understanding the fiscal impact of the nurse licensure compact. We had forecasted it, and we actually had written multiple reports about it. We had done a survey with all of our nurses about it. But we're coming to the close of our last renewal of the nurses, which is our registered nursing renewal. That renewal closes on March 31st. And we are projecting that we're going to lose about a third of the nurses that we had previously. So that's a significant impact. It's about $2 million that we're losing from nurse revenue.
Representative Hango has a clarifying question.
Not a clarifying question, just a comment. I really appreciate you bringing this up because that is concerning. I mean, compacts are certainly really helpful in terms of administration. I'm sorry to hear that the state is losing that money, but I really hope that it's probably Ways and Means doesn't consider raising the fees for your other regulated professions to cover that $2 million loss, because that would really be a burden on many, many small operators.
Yeah. So we do have a fee proposal in front of Ways and Means now. And I think Ways and Means is really grappling with all of those questions and concerns. Part of it is the model of OPR may not work with the public policy and benefit of compacts and what needs to happen. So we're having those conversations. And I just want to say the other piece about compacts is there's almost always an impact on the enforcement process as well. Vermont always has jurisdiction over the professionals that are operating within her borders, whether or not they hold a Vermont license, which means that it can just add some complications. So there could be somebody who's practicing in our state and has a compact license from Virginia. That nurse, he came up here to practice in a facility and he does something wrong. We still have jurisdiction over him. We can still prosecute him and restrict his ability to practice in our state. But that can add some complications in terms of how do we find him? How do we contact him? All of those things. So
when was the last time there was an evaluation of the fees across OPR? I mean,
the last time we brought any fee changes was in 2019. But the last time the majority of our fees were changed were in 2011. I believe. I'll have to check that, double check that.
Thanks. Representative Cooper.
If I could just say one more sentence on that. Since 2011 and even since 2019, since 2011, we've had to upgrade our entire IT system. We've needed to change multiple processes. We've responded to COVID. Also, our licensee population has grown by almost 2/3 since 2011. I think we had 35 and now we're at 85, so 1,000. So we've rapidly grown. And as such, our costs and administration has grown as well.
Representative Cooper.
Too quick. The nursing board, the fees are segregated to funding the actual profession. So there won't be a bleed over from the plumbers to the.
Well, right. So there'll be no effect on any profession that OPR doesn't regulate. But the way that we do our allocation is we take our total, and I'm sorry, I don't have my numbers in front of me. So I'm going to speak in broad numbers and not specific numbers. But the way, our operating budget per year is approximately, don't hold me to this, approximately 7 million. And if the way that we allocate the cost to professions is we take the number of licensees in each profession, we divide our costs, and that's the cost per licensee. Now, of course, if you lose licensees, then the cost per licensee goes up. So it does cross professions within our house a little bit. We're trying to do our best to mitigate that.
And secondly, prior to the compact being adopted, when somebody had an insurance claim and a nurse reviewed it in Virginia and didn't possess a Vermont license, is that considered and made decisions upon the treatment you were eligible to receive?
So you're talking about a nurse who's employed by an insurance provider who's making clinical decisions on care based on, I have to say, Representative Cooper, I don't know whether, I believe that would be considered the practice of nursing and that person would need to be licensed if it's a clinical review and clinical discussion. But I'm not 100% sure. Maybe, do you know?
If it's for reimbursement decisions and not for care choices for the patient, then no, it's not practice. So if they're doing that clinical review on behalf of their employer to decide whether to pay for the care, it's not considered the practice of nursing in Vermont.
Because it's not directly with a patient.
It doesn't ultimately decide the care of the
You
patient.
can get it if you want, but pay for it.
Exactly.
Fine line.
It is. And then the other piece that I just would like to speak to on compacts is post-Dobbs, the world is a little bit more complicated with compacts and in occupational licensure. We had not really contemplated that until the Dobbs decision was issued. Because in other states, professional boards are giving licensees for providing abortion care, and we're also seeing it with gender affirming care. And a lot of the compacts are written in a way that would require our state to recognize and immediately discipline on the basis of another state's actions. And we do not, clearly Vermonters do not, and we do not want to discipline somebody who's licensed in Texas and in Vermont because they provided an abortion in Texas. So we have worked really hard with our existing compacts to find solutions around this problem. It is not a problem in the nursing compact. There's no mandatory discipline or enforcement of another state's discipline. It was a problem in the physicians compact, and our team was in the rules revision of the physicians compact this fall in Alabama. And our team was part of the current resolution, which is not perfect, but it was a large compromise. And it's unfortunate because it it really is, it was very contentious. And the compromise was that we do not have to discipline that person from Texas who provided an abortion, but they would not be able to use their compact license in our state. They would need to obtain a single state license. It was a complicated road to get there, but that's where that compact is. We're watching that in every other compact that we're coming across. We've raised it in the counseling compact. It also is an issue in the speech language pathology compact. I don't see it as an issue in the PT compact right now, but we'll want to make sure that we continue to watch that.
So you'll be prepared to offer feedback on each one of the compacts in relation to the reciprocity and the issues that were brought by the Dobbs decision?
Yes. And we're in a fortunate position with some of the compacts because the rules haven't been written yet for the compact. So the problem with the physician compact is the rules were written before we knew about the Dobbs decision. And so that, it hadn't even contemplated that scenario. It thought, of course we would discipline a Texas doctor if he diverted narcotics during a surgery. Like, that's a no-brainer. But we hadn't thought through these sort of political and state differences on abortion or gender affirming care when the compact was initially adopted.
Thank you. Representative Hango.
Clarifying question. So this would be a provider who is licensed, let's use Texas for an example, in Texas, and belongs to a compact and is practicing in Vermont, doing or providing an allowed procedure in Vermont. We have no jurisdiction in Vermont to discipline that individual just because the law in Texas, for instance, says they cannot provide that procedure. We have no jurisdiction whatsoever about what that provider does in Texas. Is that correct?
That is correct. What somebody does in Texas, we do not have control and authority over. But if Texas disciplines a physician, we want to be able to look at that discipline. And this is what we do with all of our licensees who are licensed in multiple states. We want to look at that discipline in Texas and say, does Vermont think that that physician's conduct necessitates Vermont to also act?
Because of Vermont laws.
Because of Vermont laws.
Or something like diverting narcotics, we would have the ability to say you cannot practice in Vermont any longer because you violated a Vermont statute in Texas.
That's correct.
Wherever you are.
Right.
Okay.
Yeah.
Great. Thank you.
And it's a really important piece of, I suppose I should have started even higher. So each state wants control over what happens in its state. And Vermont wants that too. But we want to be able to communicate with our sister states and have knowledge of what's happening in their state, because we know someone who's diverting narcotics in Texas is going to be looking for a job in Vermont tomorrow. They just got fired in Texas. They're going to be here. So with nursing, we have a phenomenal system that it's almost like the roots of a tree. We're communicating with each other all the time between the states of, what's happening in Texas and how might it impact Vermont. And other professions, we're building those networks. So if a nurse diverts narcotics in Texas, then we just want to be able to know that so that we can immediately restrict that nurse's ability to practice here.
Can I ask a quick follow-up, please?
Sure, and then Representative.
Thank you. Are any of the compacts nationwide at this point?
No. The closest is the nurse licensure compact. It's almost, but there's some holdout states. And probably physicians is next, and then PT is right after that. And those are the three most established compacts. But, it's fascinating. I love this topic because some states don't need compacts. New York and California may never join the compacts. They have enough professionals in-house. They grow enough of their own. They don't have market pressures to have compacts. The smaller states, the rural states, typically do adopt compacts. The Midwest states almost always do. If you look at the maps, there's themes. Vermont is kind of behind in adoption of compacts. If you look at it in one light, New Hampshire's almost always first. New Hampshire loves compacts. And Maine also is an adopter of compacts. Massachusetts is not. And New York is not. Connecticut, Rhode Island are.
Sorry to, one more follow-up. So how does that affect folks who live in New York and want to practice in Vermont because the nearest hospital, for instance, is in Vermont or Massachusetts, same thing. So we don't have any agreements with those states.
We do not.
They have to apply for a Vermont license.
That is correct.
Thank you.
Could you just, so for instance, like what is the cost of a nursing license?
Currently, the application is, I think, around $100 and the renewal is $190. And we are a little higher than New York and New Hampshire. I think maybe on par with Massachusetts, but I don't have that data right in front of me.
And when you have a Vermont license, because we are in the nursing compact, you have the ability to use that license to practice in any of the states that are part of that compact.
If you live in Vermont and you apply for the compact license, you have to be a resident of Vermont and you have to apply for the compact license.
Representative Chase.
And those are for 2 years?
2 years.
Thank you.
Yes.
And a compact license is an additional fee over their regular license?
No.
Okay.
It's the same fee. So when you apply, right now, nurses are going through the system. You may hear from constituents about this issue. This is the first time, the first renewal that nurses are required to get fingerprint supported background checked. And public safety has a large backlog because of a variety of factors, including this sort of bulge in the pipe of fingerprint supported backgrounds. So you have to, right now, a nurse who's renewing, when he or she comes into the renewal system, they select, they want a single state or a multi-state license. The fee is exactly the same, but all of them are getting fingerprint supported background checks. And we made that policy decision, because Vermont, before we started that, Vermont was one of 4 states in the nation that did not require a background check for nurses. And it was quite alarming. You could Google, where can I get licensed with a criminal background check and get away with it? And Vermont came up. So that was a little alarming and we solved that.
So Representative Hooper, and then I want to wrap up this conversation about compacts for now. We'll get back to it this afternoon, take a quick break, and then the bill, if that works for your schedule, Deputy Secretary Hibbert.
It does.
That scenario which you just detailed led to somebody stealing somebody very close to my prescription pad. Initially, you said 2 states can join in a compact. Is there I used to deal with the Interstate Compact and Protection of Children, which was created by somebody that loved papers to fill out. And it seemed to be fairly national. Before you would move a kid to another state, you had to go through them. Is there a discrete clearinghouse basically for each one of these compacts that we get into?
Yes, there's a couple of large organizations that have been participating in the compact discussion. I would say that CSG, the Council of State Governments, is the largest, but they've been working with the Department of Defense. And I do want to say, I should have said this about compacts, particularly because of your military affairs portion of your committee, that compacts are widely seen by the Department of Defense as a priority because they allow military spouses, the spouse who's moving with the military member, to use their occupational license faster. They also enable continuation of care for military spouses and families and military members across family lines, across state lines, rather, and through the use of telehealth So compacts are broadly supported by the Department of Defense.
We did
Oh,
something.
and yeah, and I'm just going to let Lauren augment if that's okay.
Yeah, please.
So it's not just between two states, it's among however many states join the compact. So right now with PT, I think there's 33 states. And when they reach a certain threshold of states joining, a commission forms.
Okay.
So a centralized commission then creates rules for the administration of that compact in multiple states. And those rules, by adopting the compact, you agree as a state, hey, those rules are becoming law in our state. And that's where the modification to the IML, to the physician compact came in, where we were able to address this kind of reciprocal discipline issue through the rulemaking process.
And an important piece of that is in any compact, once we join, we're a voting member in the compact. We're part of the commission. So we can go and agitate for change or say this needs to be modified or be part on the ground floor of rulemaking.
Yes.
So last question. In the situation you described, the person from Texas that was licensed to blah, blah, blah. What is the hierarchy of, I mean, we just passed a constitutional amendment that should carry a little more weight than a contract with another state for doing something. Is that legitimate?
Yes, so what the compromise was, so under the original contract, and I think that's a key piece too, is when the compact legislation comes before you, it's a contract essentially between all the states that are agreeing to this. So you can't change the terms, you can't amend the terms, you accept it or deny it, or refuse it. And one of those terms in the initial compact for physicians, and is in many of these, is if somebody's home state license, so the state they live in, gets disciplined, then all of the remote states they were working in have to revoke that license. And under Vermont law, to revoke a license, you need to go through a due process situation, which would have OPR prosecuting to remove somebody's license under the laws of Texas that contradict our Constitution. So we weren't going to do that. The option was either fix the rule or withdraw from the compact. And we got in there and were able to fix the rule kind of with the compromise that that person, we could choose not to prosecute them, but their compact, they would no longer be working in Vermont under a compact license. Instead, we would give them a state license in Vermont.
And it sort of comes back to the driver's license. If your driver's license in Connecticut is revoked because you were going 90 around, through 84 on that interstate, it's revoked in Vermont too. You're not allowed to practice it. You're not allowed to drive in Vermont because your Connecticut license was revoked. It's a very similar concept. It's your authority to practice here or drive here is only because your home state has given you the license. So the solution with the physicians compact is, okay, you don't have to prosecute them, but you can issue them a single state license.
They're not part of the compact.
So that physician goes outside of the compact.
Yes.
Just one quick follow-up, hopefully. So you talked about the rules, and you have a part in that. Who is ultimately the deciding group, or is it a vote by all the?
It's a vote by all states.
Okay, thank you.
Yeah, that are members, only the member states.
Yeah, thanks.
So we've been on for about an hour and a half. I want to give the committee a 15-minute break. We'll be back here at 10:45. You have one last question, Representative Waters?
No, I was just holding my hand like.
Oh, okay. No, I'm just trying to make sure everybody gets in. So we will go off.